Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another edition of Legal Bites. You know, I'm not a doctor, but this Legal Bites is for your health and safety. So I'm not going to give you any medical advice, but I'm actually going to talk about one of my biggest frustrations, and something that I see a lot of problems with are these, in my opinion, sort of stupid inspections are limited to only health and safety items, right? A lot of people are using these kind of canned clauses, often very short, you know, just what I said. Buyer agrees to limit any inspection objections to health and safety related inspection items or resolution items or however it's written, but it just refers to health and safety. That is ambiguous. It's too ambiguous in my view, and it creates an increase in what I'm seeing in terms of earnest money disputes or contentions in the contract, and sellers saying, yeah, I'm not going to release your earnest money because I don't believe that the problems you've identified are health and safety. And so, you know, I'm the lucky recipient of the phone call, or the other attorneys on the hotline get the phone call and say, well, isn't this a health and safety issue? And I say, I don't know. I mean, some cases it's very clear, right? If they do an inspection and they find, you know, methamphetamines dripping from the ceilings, which I don't even know if that's a thing, but, you know, it would be certainly a health and safety issue. I think we can all agree there are certain categories of items that are truly health and safety concerns. And that's an extreme because it's easier to talk in extremes. You get my point. Asbestos uncovered everywhere. You know, legitimate, explicit environmental concerns, clearly health and safety kind of issues. But I'm going to give you an example from a call I got not long ago from a listing agent who said, my sellers don't want to sign an earnest money release with the buyer because they had a health and safety clause in there, and my sellers accepted the contract because they thought, well, we're going to have, you know, probably not even an inspection objection at all. And if so, it's only going to be something that's very limited or specific to health and safety issues. Well, this buyer sends over a termination based on inspection, and they inquire as to why. And the health and safety concern that the buyer had was when they inspected the home, they realized that the garage was too small to fit the buyer's truck, and therefore it was a health and safety issue. And when further pressed, the buyer's response was, well, because the buyer owns a truck that's this size, they're not able to park the truck or fit the truck in the garage, which means that they're going to have to park their truck outside or on the street or in the driveway or wherever it was. And because of that, they were going to have a higher propensity or likelihood that they were going to have to navigate over icy sidewalks or streets. And therefore, if they slipped and fell, that was a health and safety issue. And I'm not kidding. That was an actual example of a call that I had. And my response was, I don't know, I guess slipping and falling, you know, hurting yourself is a health and safety issue, but I don't really know how that fits into the contract as a whole. And so I use that as another extreme to be illustrative of the fact that there is inherent ambiguity in that statement of just health and safety issues. So listen, if you're going to use these things, first of all, and I've got one better piece of advice for you here, but if you're going to use these things, I think they really need to set expectations of both the buyer and the seller a little bit better with regard to what somebody expects or might expect to be a health and safety concern. Because just generically, health and safety is pretty open, and one person's health and safety issue might not be the other person's at all. And so it leads to that bad faith or inability to terminate sort of ambiguity. The other thing I guess I would say is the easiest is, and I say this with a lot of inspection issues, including inspection waivers and such, is just shorten the deadline, right? If you're a seller, what you really want is to get past that inspection period as soon as possible. And so it makes much more sense, as opposed to writing ambiguous clauses or trying to limit the scope of your inspections as a buyer, to just say, listen, it may cost me a little bit extra, but I'm going to get us an inspector out there within the next 3 or 4 days. You know, I might have to pay a bit of a premium for a rush inspection, or might have to do something, you know, buy the inspector a case of beer or bottle of whiskey or whatever it might be, but I'm going to get them out there quick, and I'm going to waive, you know, I'm going to still have the ability to object. I'm not going to limit that, but we'll get that done in the next 3 or 4 days after we get under contract. I think in most cases for a seller, you're practical and understand that that's probably better for me and more realistic for me as a seller to expect of a buyer than it is for them to either waive inspection or to limit objections to things that I'm not even exactly sure what they are. So anyhow, that's, to my mind, the best practice is just shorten the inspection time frame and get through that at an earlier date and time as opposed to writing ambiguous clauses. Anyhow, I get it. This market's demanding a lot of unique expectations on buyers from sellers because of the multiple offer situations, but be careful how you're trying to address some of those concerns in order to write better offers for your buyers. If you have more questions about this or anything else, Car Legal Hotline is available from 9 to 12 and 1 to 4 Monday through Friday. And with the exception of when I'm answering, you can always get a competent and capable lawyer to answer a question. With me, you'll just have to deal with me. All right, guys, we'll see you on the next edition of Legal Bites.